If able. The appeal in the name of the children.
Yes, just give me a moment, Mr. Bond. Take a seat. Yes, my apologies. Now, thank you, Mr. Barnes, for
My
reading.
Lord, good morning, my lords. If it please the court, I appeal on behalf of the appellant mother in this matter. By way of introductions, my learned friends, Mr. Miller and Ms. Hughes, represent the local authority. The children are represented through their guardian, who is in attendance, along with the solicitor for the child, represented by my learned friend, Mr. Melser. Both Mr. Miller and Mr. Melser have the advantage on me of having been present at the hearing on the 26th of March.
Yes.
My Lord may have picked up that my first involvement was on the same day that my Lord Justice Peter Jackson first saw the case on the 28th of March, shortly before the...
Right, so who is present in court in terms of family members?
Yes, I'm accompanied by Ms. Singh from my office. My client is in the far corner, along with the maternal uncle.
Yes.
They both take up that position by virtue of the live streaming, and we anticipate
Yes.
that may allow them to be off screen. If I address that matter first, I hope my lords will see a short document has been placed on your desk that is merely to try and assist. It's entitled "The Key Participants in the Case."
Yes, well, we are dealing here obviously with a case involving children, and so nothing is to be reported which identifies the children or their family members, and we will all do our best to maintain the confidentiality of their identities. Particular care is needed if one starts reading out anything off a piece of paper, but please don't be too alarmed. There is a way of dealing with any important inadvertent statements. So you've given us the key. Thank you very much.
As my lords will be aware, the matter proceeds as an appeal against the decision of Coroner Judge Jacklin KC sitting at the CFC on the 26th of March. That was an order permitting the interim removal of A, C and D on the lettering that I have adopted, from the care of their maternal grandmother, who I believe is en route to court but hasn't yet made it,
Right.
and the maternal uncle, who obviously is present. That order, which sanctioned the interim removal of the 3 children from the care of those 2 relatives, was to be given effect on the 28th of March, and that was the same day that my Lord Justice Jackson granted an urgent stay. I should express at the outset my client's sincere gratitude for the court, both in managing the urgent process of the stay ahead of the long Easter weekend, but also the speed with which the matter has been brought on for hearing today. And my lords will be aware, for the avoidance of doubt, that in respect of B, there was an agreed move to his father, and that isn't a matter that's subject to the appeal.
Can I, for our part, thank the parties for the efforts that have been made, I think, probably particularly by those instructing you to have matters ready for us to consider, including the efforts that have been made to get the transcript of the judgment, which we now have. Could I really only, for the purpose of encouraging good to become even better, make one point which we see in quite often in family cases. This court has judges with different backgrounds sitting on it, and although it's a family case, yes. So the family is now all here.
Yes.
Although it's a family case, that doesn't mean that the basic statutory provisions shouldn't be included in the authorities bundle. So perhaps as counsel in future you could hold that in mind. I don't think that we're going to be concerned closely with the provisions, but they should nevertheless always be there in relation to an appeal of this kind.
Well, I offer certainly my apology for the fact that that isn't present. I hope I might just confirm at the outset that the bundles that my lords do have, as my lord has noted, there's been a considerable amount of work, certainly by my instructors, Miss Richardson and Miss Singh, who accompanies me today. My lord should have a core bundle for the appeal. There is then a separate bundle which relates to my client's application to admit the fresh drug testing evidence within the appeal. It's a discrete bundle.
Well, is that the supplemental bundle?
Apology, that is titled Bundle Relating to the Appellant's N244 Notice, and
No.
I apologise that there is then a separate supplemental bundle.
No, well, I do have a supplemental bundle.
There is
I have
additionally
both a supplemental bundle and an appellant's N244 notice
Yes.
bundle.
Yes.
And then finally there is a short essential authorities bundle, but obviously too short given the absence of statutory provisions.
Right. Well, I have all of that except the supplemental bundle relating to the fresh evidence. I'm aware of the fresh evidence and have seen it in other contexts. But if anybody has got either an electronic or a hard copy version of that I could use, I'd be grateful.
Yes, I'm sure Ms. Singh will be able to manage
Well,
that.
if Ms. Singh is able to send it to my clerk will send it on to me, and then I'll have it that way, or I'll receive a hard copy in due course. That takes us to the management of this appeal, and if I may, I'll tell you how we'd like to proceed. Clearly that you have 2 applications. First, the permission application with appeal to follow, and secondly, the fresh evidence application. We'd like to hear you ignoring the fresh evidence in the first instance, so that we, when we've reached this point in your submissions, have a clear idea of what was happening up to the point the judge made her decision on the evidence that was then available, and what your submissions about that are.
Yes, my lord.
We will then move immediately to hear you in relation to the fresh evidence and why you say it should be admitted, appreciating that if you get to the point where you get permission, it's not opposed. But we would like to have as clearly in mind what the further testing evidence does and doesn't show, so that we can consider its significance at that point.
Well, my lord, I'll certainly endeavour to adjust matters to accommodate my lord's indication. I should say that in discussions outside of court, both Malone and friends confirmed that whilst in their arguments the sequence that they adopt is a consideration of permission, then a consideration of the new evidence, they are content and don't oppose the admission of the new evidence generally on the appeal, but obviously it's still a matter
Well,
of
if I may say so, that's very sensible. It would be unreal for us to approach matters in any different way. When we come to hear from the local authority and from the Guardian, one thing that we would be helped by is to focus clearly on what inquiries had been conducted by each in relation to understanding the tests that were available at the time of the judge's hearing.
Yeah.
In other words, what have the social workers done in order to work out what explanation there could be for these tests if they're forensically accurate? What inquiries had the Guardian herself undertaken? In other words, how they, as parties, had armed themselves in order to give advice to the judge as to what should happen to the children. Anyhow, I mention that now so that everybody should know what will help us when we go.
My lord, it chimes with an observation that it doesn't form part of the appeal, but is relevant in that the judge, I think, indicated on the 26th of March that the children were not aware of the application, and the degree to which their wishes and feelings have been obtained as well. It is a matter that I think had been let lapse, which is particularly striking in the case of A, who is obviously now 13 years old, and that's a matter that may be in any event relevant when the matter returns to.
And what is as a matter of just so we know the context, what is the state of the children's knowledge of all of this at the moment?
Yes, so on the 26th of March, they were visited by the social worker, who, as I understand it, outlined the indication of the judge's decision and the intention to execute that removal on the 28th of March, which was following the last day of their school term. Obviously, following the stay that my lord granted on the 28th of March, the children were updated as to the fact that they would not immediately be separated from their grandmother and uncle. As I understand it, since that date, there was a visit that coincided with Eid on, I believe, the 10th of April. And there may, I think, there was an indication I was given by Mr. Miller, have been a visit yesterday, again to potentially explore with the children the fact that this hearing was happening. But I don't have any more general information about that. I would only observe that that is a striking decision from the local authority that came to the judge saying that 24-hour monitoring was required in order to ensure the safety of the children. And I understand no welfare concerns have arisen subsequently. So the children are obviously aware that these proceedings are in train.
This is not something that is particularly highlighted, as I recall, in the written papers, but do we find information anywhere up to the 26th of March about these children who are not babies being asked about the results of their tests?
There is a general dearth of information, given that this placement had at the point of the 26th of March been ongoing for, I think, some 8.5 months. There is a yawning chasm, in my submission, as to the
Well, I
information
wasn't at the moment
about that
asking, I
placement
wasn't asking you
generally.
to make submissions about this. I just want to pick up
In
at
short,
a convenient point and in due course whether, as part of deciding whether it was safe for the children to remain in the house, anybody spoke to the children, particularly the older two, and very particularly the eldest, about the outcome of the tests, or even obliquely about the issue of drugs exposure to in the home or elsewhere.
it is not my understanding that that was explored. It certainly isn't any of the written material, which is the principal basis, and it isn't referred to in the judge's judgment or any of the position statements, as far as I'm aware.
Okay, right. So with that, those preliminaries,
Thank you.
back to you, Mr. Barnes, to present the appeal.
Yes, if my lords are content, I was going to outline just the approach that I was intending to take, obviously slightly modified by my lord's indication as to seeking to disaggregate the two processes. I was going to briefly introduce firstly the scope of the issues on appeal and outline the helpful and numerous areas of common ground. I was going to touch on the issue of the new evidence, but given that there's no resistance to it being admitted, that probably requires little to be said at this stage, but I'll obviously return to it generally. I was going to briefly touch on elements of the background, but I'm sure that the lords have some of that in any event from the papers, but there were just a couple of points that I wanted to pick out. I then wanted to turn to have to look at the judge's extempore judgment, just to analyse how that process was considered by the judge in coming to her conclusion to endorse the local authority's invitation to permit them to separate the children from their grandmother and uncle. I then wanted to turn to what I intend to take as grounds 1 and 3 together. I think there's a substantial amount of overlap, and I hope that's convenient, though I suspect that can be taken more shortly, and that is under the broad headline that the judge was wrong not to adjourn to await the further testing in the circumstances of the case. I was then going to turn to ground 2, which is the substantive ground addressing both the hair strand testing as it was available, the conclusions the judge drew on that, and the impact on her decision, and in short, to flag the appellant's cases that my lord's warning, I think in one of the last judgments that my Lord Justice Peter Jackson gave sitting in the High Court in the hair strand testing case, that one must be cautious not to elevate hair strand testing to being presumptive or determinative of issues. It is a matter that should have inclined the judge to give anxious consideration to that testing, what it could and could not establish, and that her conclusions were not sustainable on the evidence that was present on the 26th, and that issue is then put beyond doubt in our submission by the new evidence that's been received. And then I was going to touch briefly on disposal, if that assists.
I'm sorry, I should have made clear, but I forgot. One of the things that we'll want to hear from Mr. Miller about, if we may, so that we have the whole picture when we come to consider the outcome, is what the local authority's position is under an interim care order if the appeal was allowed.
Yeah.
So we know the disposal question as clearly as we can from all angles.
Yes, and my Lord, just to flag, my principal case is that a return to the status quo ante that existed on the 26th of March is appropriate.
Yes, well, we'll need to know what the local authority's position is about that.
And I think Mr. Miller was also seeking instructions in relation to the availability of an immediate placement, obviously subject to the decision that the court arrives at.
Yes.
So, my Lord, in relation to the scope of the issues today, plainly, my Lords listed the matter as permission with appeal to follow, with the application to permit evidence. There is a strong degree of consensus as to the appropriate principles to be applied, and they arise within the narrow authorities bundle. So, my Lords, in relation to new evidence, we have Lad and Marshall in the bundle, in the authorities bundle at pages 1 to 6, and the additional consideration of that within my Lord Justice Peter Jackson's lead judgment in E children, that's in the authorities bundle at 20. That confirms the conventional Lad and Marshall principles with an appropriate flexibility to incorporate the consideration of new evidence, but as my Lord stresses, not that that shouldn't be implying laxity of approach, but as my Lord has indicated, the realistic course here is that the new evidence would need to be considered here and would need to be considered at first instance. On the question of interim separation, all parties are in agreement that the judge identified the correct test, as summarised by, again, Maud's judgment in Re C, and the familiar 5 principles that outlines. That's in the authorities bundle at page 38. And then the parties also directed the court's attention to the case of Re H, a child. And as I say, that was a decision that at first instance, with my lord sitting then in the High Court, which included both a wide-ranging consideration of the previous case law, but also a substantive challenge to the overall efficacy and reliability of hair strand testing involving a number of the hair strand providers, though notably not the 2 who brought in this case, participating within that hearing as interveners. It is right, I think, to identify that I'm not aware of hair strand testing being considered at the Court of Appeal level previously, or anything other than a tangential fact. This case obviously arises in a somewhat different context to the context in which a number of those decisions that Lord Justice Peter Jackson considered in that first instance case, in that this concerns the deployment and relevance of that evidence at an interim stage, without perhaps some of the more in-depth questioning and consideration that has arisen when previously hair strand testing issues have been considered at first instance. And it certainly gives this court the opportunity to consider the degree to which those principles might apply to interim cases where, of course, the limits of time and the likelihood that evidence may not be taken, the appellant would submit, increases the risk of precisely the potential for error that my lord and other judges have previously identified of elevating hair strand testing to a point that considers it presumptive rather than one piece, potentially an important piece, of an overall evidential picture. My lords, save for saying that in our submission, and it is, as my lord says, appropriately conceded, right, that the new evidence is considered, we say that both that fulfills the criteria set out within Ladd and Marshall, and if there is any doubt in relation to willingness of family member to participate in testing being a cause of a delay in those results being available, that is where the proper application of flexibility should lead this court towards admitting that evidence and considering it. So, I hope that assists by way of a general introduction as to the scope of the hearing. Turning then to the background briefly, I've obviously set that out principally within the skeleton argument at pages 33 to 35 in the core bundle. That's paragraphs 7 to 15. There is also a broader chronology within the bundle at page 353. And I apologise that there may be a title page that means that electronic versions are one out from the paper
We have
copy.
that, thank you.
Apologies for that. The children had all been living with my client up until July 2023. My lords will be aware, and it's obviously stressed as a relevant factor, which I respectfully accept, that the particular events that gave rise to the proceedings and the principal concern related to C's admission to hospital following a collapse and testing that suggested that there had been some ingestion of topiramate. There was agreement at that stage at the end of July, beginning of August, between the local authority and mother that the children should move to their maternal grandmother with the support of their uncle. And the court is obviously will be aware of the nature of the grandmother's employment. I won't detail it specifically, but that was a matter that both highlights her responsibility and so on, would, in my submission, be a striking point to consider in the likelihood of some of what was suggested as being the potential explanation of a wide range of Class A drugs being exposed to the children in that placement. And in my submission, the overall picture is of a very positive placement for the children, setting aside the issues that I accept were a pertinent concern as at the 26th of March of engagement with hair strand testing and some degree of ambivalence about proceeding with a special guardianship assessment.
Well, broadly speaking, and we have all the details,
Thank you.
everything was going well up until the end of the year.
Yes.
Obviously, the circumstances in which the children left their mother's care were going to need careful consideration, but that was a decision for the future.
Yes.
But the interim arrangements were not subject to any professional criticism, far from it, up to that point. And what then set matters on a different course was the sequence of events that began with the receipt of the tests.
Yes.
At the beginning, the further tests.
Yes.
At the beginning of January. So you can take it that we're secure in our understanding of the situation up until really January.
Yes. Well, the judge summarised it as very good care. The reference that I have is at Core Bundle 198, if that exists, but I don't intend to take the court to it. There was then testing undertaken by Forensic Testing Service, FTS, initially for topiramate in relation to all.
Right, so those tests were taken on the 26th of October
They were,
and reported on,
I believe, in November. I believe it was November.
23rd of November.
Yes.
So 26th of October topiramate tests to the 23rd of November. And all of that was going to go into consideration of what had been happening in the mother's home.
Yes. And for the avoidance of doubt, again, there was specific evidence that whilst there had been evidence of headaches, that had dissipated. I think the general view was that there was no suggestion of topiramate being administered within the maternal
So we might pick up the story with the taking of the FTS samples for a wider range.
Well, that's the first point, my lord, which doesn't sing out clearly from the judge's judgment, but my understanding is that the sequence was that FTS were invited to test for topiramate, but also, in the course of that reporting, identified that they had noted other metabolites being present when they had undertaken the sampling. They invited the parties then to endorse a position where further testing was undertaken of that original sample, and those were the tests undertaken towards that were reported on towards the end of January, I think on the 27th of January. So it is a key point of distinction is that there weren't fresh samples taken approximately to the January reporting date. The samples still related back to those same samples taken at the end of October.
Right, and if it matters, can you remind us these were hair samples or were they also nail samples?
I believe that there were hair and nail samples that were taken originally.
And that of the 4 children only. I think this might be a convenient moment if we were just to run through the sequence of tests and get absolutely clear in our mind who was tested with what, for what.
Paragraph 2.2.
Yes. Well, my lords, in relation to if starting with child A, which the original reporting is at page 99 in the core bundle. That's the report of the 23rd of November in relation to child A. over the page at 102, and if I might take it sequentially as we're on it, at page 101, my lords will see summary of findings, and the caveat there that the summary is designed to provide an overview. It must be considered in conjunction with the full test report and should not be used in isolation. At paragraph 3.1 in relation to child A, Lords will see that that was a lengthy hair strand test sample that was taken. You'll see at paragraph 3.7 at the bottom that there was 15.6 centimetres sample taken. And you'll see it over the page at 103 that the FTS standard procedure is then to also collect nail clippings. My lords will see the conclusion of that result at paragraph 4.3, page 104 of the core bundle. And that conclusion is acid exposure to pyramate likely to be multiple occasions during the period from around October 2022 to 2023. But again, note that that isn't a finding that in each and every month of a segmented analysis that there is positive evidence that can establish a particular application in that month.
Well, late October 2023 is the date of collection.
Yes.
There's the next paragraph refers to some possibility of reduction or cessation.
Precisely.
But this doesn't on the, so far it's not giving a month by month so far.
No. What my lords will then see is that the paragraph 4.4 deals with what that exposure is likely to represent, and that in the opinion of the company that didn't suggest sufficient evidence to establish ingestion by child A. There's a recommendation then for obtaining evidence in relation to prescribing history at 4.7, and then at 4.8, my lords will see the reference to additional compounds being detected and requiring further instruction to undertake that. My lords will see at page 106 that A factor is the particular hair type. It arises both in relation to coiling the hair, meaning the stretching means that the approximation for hair growth may be more difficult or less reliable in this case. There's then some discussion of washing. There's a critical distinction drawn, and also see over at paragraph 4.13, page 107, that the FTS suggestion is that for older children, the hair structure is likely to be similar to an adult, but that doesn't hold for the younger children, where there is noted to be a distinction in terms of the degree to which the hair may be receptive to material. There is then a full, there's then an appendix that starts at page 110. And the lords will see then, there's a page at 115, confirmation as to the identity of the child A that the sample is taken from. And then at page 117, as part of the appendices to the report, we then see a segmented breakdown of results.
Right, so ND being not detected.
and for the purpose of this, there are two.
Because ND is not detected.
That's my understanding. I think also the note is to identify that the particular test for topiramate isn't part of the accreditation regime. Further inquiries that my solicitors have made suggest that obviously accreditation is not a straightforward process, and whilst there are certain drugs that are frequently tested for where going through that process is economically effective, that isn't the case necessarily with drugs that are either prescribed or less frequently tested for. So that does suggest a relative degree of novelty. But there are two, in my submission, striking patterns that arise. I don't profess to be a forensic toxicologist, but there is plainly a diminishing finding and a non-detection in the very last sample. There is then a consideration of the washes, and that obviously pertains to matters that I know the law.
Well, you said there were two patterns. What are the two?
Well, the cessation, the fact that there is no detection in the last month.
Right, so diminution and then cessation.
Well, in relation to child B, those initial tests appear at page 122. In this instance, you'll see at 125 that there was a much more limited hair sample, just 0.7 centimetres, and sample toenail clippings taken. 126. Again, there's a finding that combines the assessment of the nail sample with the hair strand sample. My lord, again, if one then turns to the appendix at 138, one can see a reading, but a comparatively low reading there in relation to that specific period, and information over the page at 139 of the identification within the toenail sample taken. Moving on then to child C, it starts at 141. At 144 we have again confirmation of a lengthy sample being taken at paragraph 3.7 along with the toenail sample.
Page?
That's 144.
Thank you.
Paragraphs 3.7 and 3.8. There, my lords will see the conclusion in relation to topiramate at 4.3 and 4.4 was that there was more likely than not ingestion on multiple occasions in months from around July to September. However, again, that may have reduced or stopped in the approximately 3 to 4 week period. Again, the note at 4.8 in respect of additional compounds. And of course, in a sense, those testing results match up to what might be expected given that it was seized collapse, the approximate cause of the proceedings commencing. If my lords turn to the appendix at 158. Again, my lords will see very considerably higher readings that are present. There is a particular peak that starts in or around, the May to June sample, with elevated readings in June, July, and then again a diminution to a substantially, significantly lower reading. And then finally, in respect to child D, 163, we have a somewhat shorter hair sample at paragraph 3.7. It's 9 centimetres plus the nail clipping. Page 167, an overall conclusion in relation to passive exposure on multiple occasions during the period from around March to late October 2023, with the alternative possibility of ingestion on multiple occasions. And if my lords then turn to that appendix, page 180 in the core bundle, we'll again see a much lower level of result and a diminution over the more recent samples tested. What I say is significant is that all of those samples are broken down by what approximate to be monthly segments as a potentially helpful analytical tool. But in the broad summary of opinion, what is established by FTS does not necessarily line up to the idea that there must be ingestion or exposure within each particular month of that segmented period. The overall conclusion is a broader one as to exposure within the entire period of the testing. I was then turning to the 29th of January samples, if that assists that.
Yes, please.
We have there child A's sample report.
Right,
Rather,
just confirming, when you talk about the 29th of January sample, you're talking about the 29th of January report in relation to the same samples.
My lord has exactly. So, my lord, that's at page 201.
For child A.
For child A, yes. There's the summary at page 202. Again, noting the overall conclusion there in relation to passive exposure to cannabis, but then also additionally then to, in the case of child A, cocaine and MDMA. In relation to cannabis, that's noted to be during the period from February to late October 2023. For the other substances, it's October 2022 to October 2023.
And we infer, do we, that these are precisely the same strands that were tested before for topiramate?
It is, as I understand it, the same hair sample that was taken. Whether it is precisely the same strand of hair, I'm afraid I don't think has been clarified. What was subsequently clarified was that there was no sample B remaining available to be tested. So I suppose the possibility arises that was put to that purpose. But it may be that the reality is, what it looks like is that whilst, again, possibly for pragmatic commercial reasons, having a hair strand going through a testing process FTS have plainly tested it to the point where they can say in a report that other compounds have been detected. So, you know, the reporting certainly relates to the same sample collection, whether it is the same strand, I'm afraid I can't assist with, but it may be something that is relevant for the
I'm sure it
toxicologist
doesn't
who's
matter.
instructed.
I've quite followed that, and I'm sure it doesn't matter. I mean, one could imagine that the testing for topiramate might itself be destructive, such that you would need a second strand to do the further testing, but that may be quite wrong.
And it's right to say that the toxicologist, particularly given the nature of the test in relation to topiramate, has asked for specific information as to how that was done. And as we understand it, FTS brought in essentially a sort of outsourced pack to undertake that testing. It wasn't something they regularly tested for themselves.
Yeah.
Again, the degree to which in due course that goes to the strength and reliability of those conclusions matter, I suspect, for another day. In relation to these findings, at page 203, there's the opinion at paragraph 1.5 as to more likely than not to represent regular passive exposure. But again, there's a broad period that is identified. The absence of a metabolite noted at 1.6 in relation to not supporting inhalation or ingestion. Paragraph 1.8 is an important caveat, because it should be noted that FTS have not been instructed to undergo an investigation in relation to mother-grandmother, so they weren't able within these reports to assess the likely source of exposure. And then my lords will see similar findings, again for a broad period, October 2022 to October 2023, in relation to cocaine and MDMA. Again, my lords will see at 205 the influencing factors that are noted. There's another important caveat at paragraph 1.22 at the top of page 206. There are obviously case-specific factors. As a general rule, most sampling is undertaken in relation to children, though FTS does say that their database includes samples from children. But notes below the numbered paragraph that lower levels of ingestion can produce higher levels. It's not possible to directly compare.
The child A is being treated as if she were adult for the scientific purpose.
In relation to hair, in relation to the nature of the hair and how receptive it might be, I think yes. In relation to this aspect, I think possibly not. I think there would be recognition that as a 13-year-old you might be smaller, that might impact on how you process patterns, because you'll have seen that amongst the numerous case-specific factors include body weight, metabolism, and age.
Thank you.
There is a note in relation to cannabis specifically. I have to say, the note about migration away from the scalp is not something that appears in the subsequent testing, but may to some extent call into question how well one can rely on segment analysis in general, if it were to be the case. They plainly recommend at 1.24 that that testing of other potential carers may be relevant. But, my lords, the breadth of the conclusion that is drawn and the way in which that's incorporated into the judge's analysis is striking when one considers the appendix to this report and others, which is at 209 to 10. Because my lords will recall in relation to cocaine that the conclusion at paragraph 1.9 is that these findings more likely than not represent passive exposure during the period from around October 2022 to October 2023. when one then turns to the results themselves, one sees that there is one, the principal metabolite, which only appears in samples up until, or the approximate dates are at page 210 of the April to May window. And again, there is a non-detect in relation to the metabolite, the additional metabolite in the September to October sample. In relation to MDMA, my respectful submission, it's even more striking that the conclusion, which is generally, which is a broad one, passive exposure during at least a proportion of the period from around October 2022 to late October 2023, when one looks then at the segmented analysis, it is only in section 8 on page 210 that any positive detection is made. What I'll come to in due course is that these end up being incorporated into the judge's judgment as if the testing establishes that in each segment or there has been exposure up until October 2023, and not that the conclusion is there's been exposure during the period from one end to the other. My lords, we'll then see at 216 the principal cannabis
So
compound was
just checking that. In relation to cocaine, the first positive was April, May.
no, apologies. I believe the Lord has it at 211. It goes back to the September, October sample, which is at the bottom of that page. September, October 2022, for the avoidance of doubt.
I'm sorry, I'm working from different page numbers to you.
Of course, sorry, it would be 212 in the electronic bundle that has
Right, you're looking at page 211, are you?
labelled as 211.
Label as
yes.
211, and what is the,
Test results 14.4 to 15.6 centimetres. So that's the very far end of the
Yes.
sample from the scalp, and that is the first registering of a result for cocaine within that sample,
yes,
which relates back to September to October 2022.
yes, and so when is the most recent registration of,
That the last is in section 6. That's page 210, which would be electronic 211. So then you'll see there's an additional
April, May
metabolite.
2023, that was rather where I thought I'd got to.
Yeah, apologies.
Whereas you said that it was in relation to MDMA, it was February, March. In relation to cocaine, it was April, May.
Yes, though it's right to note that there's the additional metabolite that registers results further through period,
Yes,
and that is last in August, September. But it's striking that when looking at the detail of those results, there's a broad general conclusion of what can be established in FTS's view. But the degree to which that applies to, we can say definitively, post-July there has been exposure, I would respectfully suggest simply isn't there on the analysis, and that they specifically caution against, perhaps for good reason, that amateur toxicology may be less helpful as expert evidence than forensic toxicology, the degree to which one can then seek to go into some of the detail, that they may point to matters on which the forensic toxicologist might be invited to comment. What is the significance of a
Yes.
diminishing
and
result?
as to that, Dr. Dowse's report is anticipated.
I'm afraid I don't have the timescales for Dr. Dowse's report, which I think was principally related to pyramate. but I've no doubt will be expanded to include some aspects of this.
Okay, and just for completeness, can I thank the singer and say that the missing bundle has now found its way to me?
I'm grateful. Fortunately, before we refer to it.
Yes. Right.
It is right, again, to note for completeness that whilst cannabis compound wasn't detected, there was testing for other metabolites. That's reported at 216 in electronic 217. This is the extended panel. My lord, again, the two non-expert observations in relation to diminishing findings and more recent non-detections in relation to that aspect. Turning to B, child B, those test results reported at page 221. It's right that the hair sample is much shorter, and so the finding is said to relate to that period, but the degree to which, if metabolites can be incorporated into longer hair that is subsequently cut, the same process of some residual impact, I think is a matter that hasn't been well clarified, particularly in relation to then, you'll see at paragraph 1.10 on page 223. There is an opinion given, I think, based on the nail sample of exposure to cannabis during at least a proportion of the period. And again, a broad range is provided. At 225, and I have prefigured it, but here it now is in relation to paragraph 1.17, testing of a child's hair, and noting that hair of a child, right, it appears the cutoff is around 10, less developed compared to that of an adult. So passive contamination can produce detectable levels in the hair of children. You'll see at page 229 the reporting at in my submission at a comparatively low level, certainly compared to what has been seen in other instances. But note as well the caveat that there is the symbol applied. And of course, my lord would be familiar with some aspects of this from the consideration in 2017, but that indicates compounds and detectors level above our limit of detection but below the lowest limit of quantitation. I think my lord comments on the fact that it's appropriate to report those findings, but they may need to be treated with the greatest degree of caution in terms of the robustness of the overall conclusions that can be drawn. And my lord, at 232, we have the toenail sample, which detects only one metabolite, and again leads to the broad conclusion that my lord has seen, or my lords have seen. For child C, that reported at 235. At paragraph 1.2 on page 236, my lords will see the, again, broad conclusions that are drawn. 1.4 is the opinion in relation to cannabis. Past exposure during the majority of the period from around February to late October. Cocaine over the page. Paragraph 1.8. Passive exposure during the period. And then we have 1.12, methamphetamine and ketamine. And again, my lords will have in mind, particularly having received the transcript of judgment, the way in which those findings become the basis for the court's conclusion that the children must be removed because they are continuing to be exposed to Class A drugs. My lords then turn to the results at page 243 in the bundle. My lords, in relation to ketamine, that is not detected after the section 9 sample, which is reported at page 245, said to represent the approximate period from January to February 2023. In relation to cocaine, if one goes back to 245,
Sorry, just
apologies.
section.
It's the one
Section
occasion on
9,
which
yes.
double-sided printing
I
has
have
actually
that, thank you,
existed.
Right, so that you were referring to what, ketamine then?
Ketamine, the top line. On 245, we see decreasing identification. But then at 244 and 243, taking matters from, they say approximately February 2023 through to October, we have no
Yes.
detection. In relation to MDMA, which is the bottom line, we see again low levels, presence of compound confirmed, it reduces over the period, and there's no detection in the last sample taken in September to October 2023 on page 243. In relation to cocaine, one has a picture of a relatively higher result on 245 for both compounds. Those are diminishing across the period through to what are plainly much lower level readings towards the end of that period. And with methamphetamine, one sees that tracking from 245 with 2 samples within the last 3 that there is no detection. I should say that at 246, one has the very earliest sample that relates back to September, October, and in relation to 3 principal findings, cocaine and MDMA, there is the highest reading for both in that earliest portion. Again, there's no detection of cannabis compound, but at 252 we have helpfully set out on one single page a picture which goes from bottom right through to top left, representing coming closer to October 2023 in a diminishing pattern. There is the toenail result at 258. And then for child D, that report is at 260. Again, broad conclusions on the basis of the testing are set out at 261 and 262. And again, without wishing to be unduly repetitive, at 268 and 9, you'll also see a familiar picture where we have diminishing findings, some compounds no longer detected at the end of the period. And the same is true at 272 in relation to the extended cannabis panel. My lord, having gone through that process, it may be most convenient for me simply to turn to the judgment at this point, because I say this is the evidential picture that the court has. My lords, have the judgment of
I
Judge
think I'd also like to consider what it was that the judge was being presented with, because we're conscious that with the luxury of preparation and now about an hour's help from you,
Yes.
we've begun to understand these quite complicated test reports with a certain amount of leisure for reflection.
Yes.
I think we would be helped by just looking at the written submissions that the judge received
Yes.
about this and how they were characterised
Yes.
before we come to see what I don't think findings is correct, but what conclusions she
Yes. Of
drew
course.
about this.
My headline, and with the greatest of due respect to below and friends, both of whom appeared below, and indeed my predecessor, the degree of that assistance was limited in my submission. Within
Well, shall we just look at the submissions
Yes,
that
the
each party
supplement-
made to the judge?
yes, the supplemental bundle, not the additional one, which I think.
Well,
my
we'll
lord
call that the
has.
fresh evidence bundle, and this is the supplemental bundle.
Thank you. Yes, at the tail end of that, we have the Guardian's position statement at page 145 within that bundle.
Would it be helpful to do it in order of the parties, just so
Apologies.
the local authority was making this application?
Yeah, right. I think it's only that it's the following page 148.
Yes, well, we start with the local authority.
Yes, the hair strand testing is considered at the bottom of page 149. And then one has a consideration of the further hair strand test reports at page 150. There's a type obviously indicating they were received on the 29th. But it is presented, and ultimately it was of course the court adopted in a very broad manner.
Well, I'm not, I want to be quite clear, making this point in any critical sense, but essentially what one gains from that is the children had tested positive for the various substances as a result of passive exposure.
Yes.
And when you say that you didn't go into any more detail, didn't go into detail as to
The time.
patterns, caveats,
No.
matters of of that kind.
Matters that are, in my respectful submission, of importance when considering matters at least at an interim stage.
Because the test reports were, remind us, received on what date?
So the test reports were received on the 27th, I believe, of January. There was then a hearing very shortly thereafter before Her Honour Judge Robertson. The local authority accepts in its initial response to this appeal that those results were before the court on that day, but didn't prompt them to apply for removal at that stage. Well, that's the local authority's consideration. At page 146, one has the analysis provided on behalf of the children.
Well, we've got your
Yes, apologies.
your one before that, haven't we?
Yes, that principally set out the argument that that there should be further testing permitted. It doesn't include any analysis of the results.
Just a moment.
that is obviously particularly difficult in circumstances where the maternal uncle and grandmother were variously not represented. The uncle being at the hearing and grandmother was not represented or present, and that the degree of assistance the judge received was modest. My lord, at 146, again, this is the danger in my submission of trying to represent nuanced findings in a summary form within a short document for an urgently listed hearing for a judge who had never encountered the case previously.
Sorry, I just before leaving your client's document,
Yes.
It makes proposals in relation to the testing of mother, grandmother, and uncle.
Yes. And I think what subsequently occurred was that we had confirmation from FTS that there was no sample B, and so they couldn't be retesting of the children, and therefore a fresh testing was sought and directed. Because, in short, on the 22nd of March, at a hearing before Deputy District Judge O'Leary, the maternal grandmother had attended and said, I think these tests are wrong, or the conclusion you're drawing is wrong.
So I've understood now that the approach taken by your client at that hearing was not to get to grips or seek to comment upon the results received in January. The approach was to say, well, we better have some results now from the adults.
I have to accept that is plainly the approach taken in that position.
Again, I'm not.
It wouldn't.
I'm saying this for the purpose of us understanding, not for the purpose of criticising anybody. It's.
I think the difficulty is, as my lord identified, and as other judges identified previously, there is a risk in treating hair-strand testing result because it's a number as being definitive, and unless one properly analyses the caveats, the cautions, the precise results, looks in detail at those results, which may be a challenging task, especially when one has very
It's not just a challenging task. You know, in what the judge was given, which was a 1 hour slot, it's an impossible task.
I think it may have been 2. Certainly, she gave judgment at 12, but I accept the points.
It was a 1 hour hearing, is what this was listed for, however long it took. Anyhow, you were going to move on now to the Guardian.
Yes, it's only that. I very much anticipate, entirely unintentionally, the read on paragraph 8 in my submission that is plain is passive exposure from February to October 2023 in relation to child A and so on. They're not presented as they appear in the actual reports, which is exposure during that period, which of course raises the possibility that that exposure predated any move into the grandmother and uncle's care. And I'm not clear from the judgment whether, I mean, plainly this reports in relation to samples and takes it up to October 2023. So there may have been an implicit assumption that the judge was aware that those testing samples were samples taken some months before, or 5 months before, in fact, because the judge talks about continuing exposure. The whole case on behalf of the local authority and guardian is predicated on continuing exposure to these drugs, when in fact we had no results at all from October to March, because there wasn't a sample taken.
Right, just pause. Right, reference is then made at paragraph 9 to the mother's test results.
Yes.
Right, can we put those into the picture, please?
Yes, of course. So the mother's test results were based on a sample, I think, which followed the hearing before Deputy District Judge O'Leary. I believe that's a 292. And Lord, 296. You can see the scope of the analysis, a head hair sample, specific drugs tested, and the results reported at paragraph 6 below. No findings.
Just wait. I don't think it wasn't Judge O'Leary, it was, it must be Judge Robertson.
Right, it was Judge Robertson. Apologies. Judge O'Leary is the 22nd of March.
Right, so it was the 31st of January that the adults were ordered to provide
Yes.
samples, and all that that had produced was sampling in relation to the mother
Yes.
by the time the matter came before the judge.
And my lord, we'll see it. Page 304, we have the order from Deputy District Judge O'Leary. At page 305 in the recital, once he's recorded there, the position is outlined for on behalf of the maternal grandmother. She's concerned that the positive result is inaccurate, where the same inaccuracies could affect her care of the children and employment. And of course, again, that may partly be about the generality and perceived robustness of what it demonstrated and what it didn't, which may have dissuaded testing. And it was only, as I understand it, after the judge gave judgment on the 26th that it was confirmed that grandmother was willing to submit an and then provided a nail sample.
Can we just be clear about who was present in court at the hearings before Judge Robertson and Deputy District Judge O'Leary?
Before Judge Robertson, the grandmother was not in attendance. I think there was a process whereby she was written to subsequently by the local authority with the encouragement to undertake the testing. My understanding is that the grandmother was present on the 22nd of March, but was not able to be in attendance on the 26th due to the short notice of that listing and her working commitments.
And so far as the uncle was concerned,
I believe he was in attendance certainly on the 26th. I think he was in attendance on the 22nd because he, at that stage, as I understand it, had confirmed he was willing to undertake his own sampling.
right, but on the 31st of January?
My understanding is that neither the maternal grandmother nor the maternal uncle were present on the 31st of January.
We can pick that up if there's any comment on any of that, but essentially the orders for testing in respect of the 3 adults were made when the mother was there, but not the other 2.
Yeah. And of course the mother being represented and the grandmother and maternal uncle not least because the framework in which the children were placed under the care order doesn't afford them parental responsibility, and so they don't become an automatic party in the same way that they would as a child arrangements order, for example. If parental responsibility is granted at the same time as that child arrangements order. And my lord, I accept as a matter of principle, I think both my learned friends refer to the potential for the judge to draw an inference from the refusal to engage in testing. My first submission on that is it is not my reading of the judgment that the judge actually goes through the process of setting out that she is drawing an inference. But of course, that inference only takes one so far because the inference in relation to the period where the children have been in grandmother's care doesn't apply to findings that precede that period, doesn't necessarily follow the pattern. So the fact that inference may be available doesn't necessarily mean that it follows. It doesn't appear to have been the way that the judge approached things, and I'll come to how she frames her conclusions in considering the judgment. But my straightforward submission is that the judge's overall conclusions and analysis of what those tests allowed her to conclude as to exposure after the children's move into the grandmother's care was not sustainable on the overall picture of the testing.
The most damaging bit from your point of view would be in relation to child B, would it?
I think that because there is
Who,
a
of course,
shorter,
it's not actually the subject of the appeal. But,
yes, there is a shorter hair sample,
Yes.
and there is an identification of a low level in relation to cocaine in that window, which they identify as being September to October, which I took my lords to. I accept that. The issue there is that the degree to which one might, if one has hair that is longer and it is cut, that might represent a similar process that is well established in terms of positive findings even after cessation of use, cessation of exposure. Whether that fundamentally changes matter would be my submission on that narrow piece of evidence. And of course, the overall level of exposure is also considered in relation to child B with the nail clipping, which does not register a positive test. So it is obviously a matter that falls to be considered, but in my submission, there needs to be appropriate caution.
I appreciate the judge was dealing with an application for urgent removal. It wasn't a trial. But going back to consider your point about inferences and so forth, we have at page 283 the relevant part of the order of the 31st of January, starting at the very bottom, paragraph 35. And one then has between paragraph 35 and 48 a very long order in relation to the uncle, which copies the order in relation to the mother and is replicated in relation to the grandmother subsequently.
Yes.
But you've got that very long order, which is addressed to the uncle. It doesn't order him to do anything.
No, he's invited to do so, no doubt, being a non-party, and there is also an invitation not to colour or.
Well, and it also, I mean, it takes account of the fact that he has to consent.
Yes.
And if he wasn't to consent, it couldn't happen.
Yes.
But it doesn't deal with what the consequences of him not consenting
No.
are. Or set out in any formal sense what the basis for the order being made is, other than in, as it were, a common sense way that there have been these results about the children. But right, so the picture that we have then is that there were these results which you've taken through about the children. There was the results in relation to the mother.
Yes.
And there was the unfulfilled invitation in relation to the grandmother and the uncle.
Right. You're content to then turn to the judge's judgment.
Oh, no, thank you.
My lord, transcript makes plain that it's a 15-minute judgment, an extempore judgment given at the end of a short listing. I don't make criticism. In fact, the judge's reasoning is set out quite plainly and to the assistance of this court. The judge starts by setting out the narrow background. Paragraph 5 sets out the January further hair strand tests. And I think that is the first point at which the anxiety as to whether the judge has quite picked up on the fact that these are samples relating back to October arises. And I think the error that slips in there, I think the 2nd of January mirrors the error in Mr. Miller's position statement.
Yes.
It then says what it shows is that they tested positive, again presented in a very broad and unnuanced fashion, entirely possibly taken from position statements or from summaries rather than any detail. I fully accept. It then presents it as paragraph 6. The company, FTS, determined that this is likely to be a result of passive exposure. Sets out in relation to cannabis, and then paragraph 7, cocaine, MDMA, and so on. Paragraph 8, top of page 3, the judge notes those tests are alarming. Again, I think that the caution that I would urge is simply that without detailed scrutiny of precisely the boundaries of what those tests had concluded, but the specific question is whether it caused a risk to be identified in relation to the care of the grandmother and the uncle. And in respect of that, there are obvious aspects of the pattern which don't fit with it being an alarming portrayal of continuing in isolation. Paragraph 9, the judge sets out fairly that the general care appears to be good. It does deal with the withdrawal from the special guardianship assessment. And then sets out paragraph 10, in light of the non-engagement with assessment, 4 hair strand testing applied for removal. I think that was initially said to be pursued on the 22nd of March, and Deputy Judge O'Leary appropriately adjourned it to her Honour Judge Jacklin. It sets out the placement that my lords will be aware of as an important part of the balance. There is the confirmation at the bottom of paragraph 12 that the uncle has confirmed his willingness to engage in hair strand and nail clip testing. My understanding is that it was subsequent to the judgment that the grandmother confirmed that she too would consent, and that process was put in train within the order of the 26th of March. You'll see at paragraph 13 the approach that was made to Dr. Dowse and his recommendation that a sample be tested, but that one wasn't available. I don't intend in the course of this appeal to retread the boards for wide-ranging critique of hair strand testing as a science, but it may be a point of note that the taking of a B sample might obviate the need for further samples to be taken which are potentially intrusive for children. Its non-availability here is obviously regrettable, as the judge notes at paragraph 14. And so the judge notes that if there's further testing for the purpose of ensuring the initial test is reliable, there'll have to be fresh samples taken. And that concerns the general reliability, because there isn't any admission as to exposure at any point within the entirety of the period, but also the degree to which those results were correct or not is plainly an issue, but also critically the subtext is the reliability of the purported conclusion that it implied exposure in the grandmother's care.
Really, the bigger point which you've already made is not so much to find out whether the tests that had been carried out in October were reliable, but for better or for worse, what had happened presented an opportunity to have up-to-date tests. You've emphasised that that the issue here was continuing exposure, and you're just about to come to it. But court was not in a position to know whether there'd been continuing exposure after the period of the taking of the previous tests.
Well, certainly not after October.
Yeah. So, I mean, any data that the court was going to be acting upon in March was about 4 months old.
Yes.
At that stage, which I doubtless say emphasises how important it was actually in a perplexing situation to refresh the information.
Yeah, I'm not sure that the presentation meant the judge was aware of the fact it may have been perplexing, or the fact that the limitations temporally might exist to inhibit the potential for removal on that day, but they're plainly matters that in my submission are highly pertinent to grounds 1 and 3 that are essentially this further testing was something that was required, and the judge
I realise I'm repeating myself, but it is potentially so important that I don't want to be in any doubt about it. That so if one limits, and it wasn't entirely limited just to test results, but if one limits one's consideration to the contribution that test results made to the judge's decision, on any view, the test results could not have assisted the judge to know about the children's experiences after the 26th of October.
yes. And of course, implicit in what my lord says there is that the court has to consider the broader canvas of evidence, none of which pointed to any concern.
Well, there were some things that troubled the judge, which was to do with the fact that the grandmother and the uncle hadn't immediately lined up and got themselves tested.
But no reports of concern from the placement, no concerns about drug use recorded in the history in relation to grandmother and uncle, no concerns in relation to children.
Yes, and also the further perplexing fact that whereas contributing to the overall picture, that whereas the children's tests predominantly covered a period where they were with their mother, and insofar as there were positive results, the weight of the results covered that period in terms of the numbers. The mother herself then tests negative.
Yes. But it doesn't point to the obvious conclusion that it was the grandmother who exposed the children preceding that point, and
No.
I accept that it presents a difficult
So
picture.
there was very much a mixed picture.
And my lord will see at paragraph 15 the proposal of appellant mother on that day, supported by B's father. The sample should be taken from the children who could roughly.
The judge was giving her judgment on a Tuesday,
She was.
and the order for removal that she made was for Friday.
No, the order was that the local authority intended to remove on the 28th, which was the Thursday,
Sorry.
because that was the last day before the Easter bank holiday.
Before the Easter bank holiday, and paragraph 15 is telling us that the samples could be taken on Thursday to be examined on Tuesday,
Yes. And so they would be available in the week.
reported on in the week beginning the 8th of April, which was last week.
Yes.
So it's essentially a fortnight.
Yes. And the judge obviously characterises that as an unacceptable risk. Plainly, we now have the benefit of the fact of a stay, fact of no further welfare concerns, very limited visiting, the local authority itself.
Yes, you were going to finish the judgment.
Yes, apologies. There's then at paragraph 16, and again this reinforces the slight concern about the degree to which the judge had recognised the limitation of the testing. So the submission is made on behalf of the Guardian that the broader background is exposure to substances that are the potential approximate cause of the collapse in July. And then it says it's of heightened of concern that we have these drug testing results that go back to January. Because they reported in January, they relate to samples in October. And then the guardian is concerned that the children have continued to be exposed to such drugs for what is now going on for another 3 months.
Right.
So that was
So essentially on two grounds. Firstly, January is not correct.
yes.
And secondly, the guardian may be concerned about another 3 months, but there's no evidential basis for it
There's nothing to establish.
arising from the existing tests.
There is a caveat in relation to the new evidence in relation to cannabis, which I think I should fairly flag now. But
We're
no.
freezing at the moment on the 26th of March.
And in that circumstance, no. And of course, the logic of the position one can understand, which is that if these tests demonstrate exposure whilst in the grandmother and uncle's care, there may be continuing exposure, but there wasn't anything definitive to establish that concern. And of course, that concern could be addressed through the testing that was proposed.
Now, the only evidence that the judge had beyond the tests was the social worker's statements.
Yes, and a very, very short updating statement that was ordered by Deputy District Judge O'Leary.
Yes, the long statement doesn't bear on this because it's just to do with the situation as was going on.
And of course,
It's the social worker's 6-page statement that we have. Would it be worthwhile looking at that while we're filling in the...
I'm entirely, yeah, of course. My Lord, we have that in a bundle at 310.
This statement was filed on the...
Believe it.
Pages before it was filed on the day of the hearing.
That's my understanding, but I stand to be correct.
That's correct.
Thank you very much. So this was not, because she didn't attend, seen by the...
I'd assume it wasn't received by the grandmother. I think my client received it on the morning of the hearing.
Just on this question of attendance, doesn't relate to this hearing, I believe, but letters were being written to the uncle and the grandmother.
They were,
We have an example in the supplementary bundle at 126.
yes.
This doesn't relate to the hearing before Judge Jacklin, but to the hearing before the district judge. So the local authority is writing to 126, the grandmother, on the 8th of March,
Yes,
alerting to a hearing on the 22nd of March.
correct.
And ordering her to attend the hearing on pain of contempt. I only mention this if it's a habit, because I can't on the face of it see how that can be right.
No, I
mean,
confess.
was the grandmother or the uncle ever ordered to attend court, let alone ordered to attend court on pain of...
I think they were invited.
They were just...
Mr. Lenfen's confirmed they were merely invited.
They're really invited.
Yes.
Yes. Well, I think particularly if it's a public authority, letters of that kind can't be written. It may have been extremely appropriate, and the individuals may have been very well advised to have attended a hearing of this kind, but that's a different matter. Anyhow.
Yes, there are also, they obviously don't include an equivalent threat. There were letters that were written after the hearing before Judge Robertson. Those are at 107 and 109, which all my lords have.
Thank you.
Which were inviting cooperation with hair strand testing and assessments.
107 in the supplementary bundle.
Yes. I think that apologies, that predated the hearing that was then directed on the 31st of January. 109.
Yes.
Just returning to the to the judgment then. So the submission is recorded at
Sorry, we
paragraph.
were looking at the social worker statement.
Apologies.
I interrupted my interruption, I'm sorry. 25th of March. So can we just remind ourselves of what was being covered in that statement?
Yes. So, my lord, at 3:11, there is a background to the placement and engagement with the Regulation 24 assessment. There's the note about not progressing to the SGO assessment in the middle of the page. There's then advice to seek legal advice, which it didn't appear had been taken up by that point.
Right, so the headlines were firstly the assessment, which is dealt with starting at
Yes.
311, secondly poor engagement,
Yes.
and thirdly hair strand tests.
Poor engagement was limited, and in my submission was obviously contested as well. And then on the hair strand testing at 313, there is the visit on the 2nd of February, which shares the hair strand test results. And it appears plain that what was presented, because the maternal grandmother attended on the 22nd of March, saying that the results are wrong, that it was plainly presented as they're continuing to be exposed in my submission, but it isn't dealt with in any detail. And there's a further visit on the 19th. There is then the local authority's application towards the end of February to restore the matter for directions, but it isn't explicitly restored as a removal hearing, but that becomes what the local authority seeks to use the 22nd for. And then there's a note about not adhering to the court directions. And my lord's already considered the question of invitations and so on. There's then a whole series of consideration of viability assessments, and consideration of the placement at 315, because notwithstanding the local authority's position on
Well, basically, it's the last sentence of the hair strand test. They continue to refuse to participate. Local authority draws negative inferences, and therefore a new placement is required for safety. Yes.
my lord, then picking matters up in the judgment, paragraph 19. We have a paragraph 17, the reminder as to the test to be applied. There was plainly a submission that might not be the requisite standard, but that isn't a point taken on this appeal. The judge correctly summarises in shorthand paragraph 18 the high test that's required for sanctioning that separation. And then we have the local authority's submission. And again, how far that submission can possibly be right, I would respectfully question. Because the hair strand test from January do not indicate ongoing exposure. They might, if the local authority can establish its case, suggest some exposure after the move, but even that I would respectfully submit is not necessarily borne out by a close analysis of the testing. And then one has the local authority's submission that plainly hasn't persisted in the period following the 28th of March and the stay my lord ordered, that what would be required to monitor the use of drugs in the home would be 24-hour day supervision, and that's not tenable. The judge notes at paragraph 20 the maternal uncle's willingness on two important points, be it under what she refers to as extreme pressure to participate in testing and participate in assessment. And then in my submission, what's key to the judge's decision is the middle sentence in that paragraph. I'm concerned about these children being exposed to these drugs. There are some serious Class A drugs involved in the hair strand testing. Now, the the recognition of emotional harm caused by removal is right, and the consequences for contact is right. Paragraph 21 is correct in establishing that it would be highly disruptive in terms of a change of school. But at paragraph 22, the judge's conclusion is the seriousness of the findings in that drug test mean that the children's safety does require their removal and be necessary and proportionate response to the risks that have been presented to them for some months now. And my lord, three difficulties with that. Firstly, it tends towards the elevation of hair strand testing to being definitive and a finding, when, as has been repeatedly emphasised, hair strand testing is one potentially significant part of a broader evidential canvas that has to be considered. Secondly, the degree to which it accurately, in fact, reflects the testing result. And thirdly, the failure of the judge to step back and consider the fact that there have been many months elapsed since well, at least 2 months since the tests were reported and 4 months since the sample, in which, aside from the allegation that there was continuing exposure within the home, there was no other evidence pointing to any risks to the children's welfare in that household.
One thing that the judge didn't have the benefit of was any account from the grandmother or the uncle. When one looks at the social worker statement, it doesn't, as commonly might appear, say, I met so and so on such and such a day. I asked them about this problem, and they then said this, that, and the other about it. Is it right to understand that there is actually no record at all in the material that went before the judge of what the grandmother and uncle say about exposure of the children to active or passive drug taking in their care?
I think it is no higher than implicit that they don't accept that they were exposed within the care. It isn't formally within a statement. A statement wasn't directed. There isn't a specific report of it. Whether the uncle himself said at court on the 26th there has been no exposure, I'm afraid I don't know. I don't have the full transcript of that hearing, and I apologise. That may be a point my learned friends can assist on. And my lord, at 23, finally, the judge considers the proposal for an adjournment for a narrow period. The judge concludes it's not sufficient to protect these children because the timescales are unknown. And I'm not clear why that is the case, given, I mean, it may simply have reflected some scepticism of the intervening Easter weekend and whether tests could be reported on by the following week, but I'm not sure the basis of it more broadly. But the critical conclusion was that irrespective of when that testing could be reported, the judge didn't consider that the children could be safe for 2 or 3 or 4 weeks.
All right. Well, that's the narrative up to.
My lord, that allows me, I hope, to take my remaining submissions very
Yes, please.
swiftly. I wanted to just draw the court's attention, though my lord, Justice Jackson will be highly familiar with it, to the decision in H. Children. And in particular at page 11 of the authorities bundle. This reflects the striking feature that all of the detailed inquiries in respect of hair strand testing have occurred at first instance. That probably reflects a capacity to engage in a wider scientific consideration, as my lord did. I would respectfully invite this court, sitting at this level, to endorse and reiterate and possibly caution to an even greater extent that there is the real risk at the bottom of paragraph 25 that if that information isn't carefully assessed and scrutinised for what it can and cannot sustain, there is that risk that results will require a pseudo-certainty. And that's a particular risk when hair strand test results might need to be considered urgently before there's been an opportunity to ask further questions of the testing company. There's a very narrow range of cases where toxicologists are instructed. I know my lord had a case where there was certainly an instruction of a toxicologist, and my general experience is that toxicologists tend to present a careful, balanced and nuanced picture of how far drug testing results can sustain definitive conclusions. And that's plainly the case in the broader analysis that underlies the decision of my lord in H, which obviously concerned a specific position in relation to the mother in that case. My lord sets out helpfully at the bottom paragraph, at the bottom of page 11, some of the considerations that have been given to testing. And again, sitting at first instance, but Lord Justice Moylan, sitting in the High Court as he then was, is quoted in the Richmond case. And paragraph 22 is important, I think reflects my Lord's ultimate conclusion of that case, that hair strands should be used only as part of the evidential picture. Of course, at the very high levels, such results might form a significant part of the evidential picture. And then over the page, subject to this, however, both of those experts agreed that you cannot put everything on the hair test. In other words, that the test should not be used to reach evidential conclusions by themselves in isolation of other evidence, and records the considerable unease. And further down in the middle of page 12, my Lord quotes the decision of Mr. Justice Hayden in R. It is particularly important to emphasise that each of the three experts in this case confirmed that hair strand testing should never be regarded as determinative or conclusive. They agree, as do I, that expert evidence must be placed within the context of the broader picture, which includes social work evidence, medical reports, the evaluation of the donor's reliability in their account, and so on. Of course, that's principally focused on the taking of tests from adults whose use might impact on a risk to children. There are, in my respectful submission, additional uncertainties when one is testing children, when one is recognising the developing insight into different hair types, as to the robustness of the overall evidence base that allows definitive conclusions to be drawn. My Lord sets out helpful guidance, or 12 propositions, many of which have been taken up by the testing companies, as to the relatively constant rate of hair growth, but that is obviously
Yes, okay.
everyone's on. So, my Lord, I would respectfully submit that the critical conclusion on that is that one must treat hair strand testing as a part of the evidence and not determinative. And that risk is particularly acute where everyone is working at pace and in constrained time. And so, my Lord, in summarising grounds 1 and 3, the judge was wrong not to adjourn. In my submission, it's plain that the time that had elapsed did not suggest that there was such an acute risk that a narrow adjournment wasn't appropriate. The judge couldn't then know what that testing would show, but in my submission, that was important, necessary information, and the decision should not have been taken on that day. And that's particularly in the context, in my submission, of the five matters that apply as at the 26th of March, the good care that was being received, the fact there was a level of dispute in relation to the testing, the fact that the samples were related to samples taken in October with results in January, that there was an intervening hearing in January, that there was in fact no other evidence of concern about drug use within the household of the grandmother and the uncle, and of course, fifthly, that further potentially highly significant information would rapidly be available.
What's the relevance of the intervening hearing in January?
That the local authority had the same tests in
Yes,
January,
yes, but,
and
Yeah, but that's just, they didn't apply then, they did apply later, after they were dissatisfied with the level of engagement, so.
but it goes to that narrow window of time potential, in my submission. Disaggregating matters then, my headline points in relation to the subsequent testing in summary form.
Right, are we going on now to the fresh evidence?
If my lord is content, otherwise I'm happy. Thank you.
Yes,
In relation to that obviously appears in the supplemental, or the additional bundle. The headlines within that, if we take the very short conclusions of the adults first, at 138 in that bundle, which may be electronic 139.
no, that's, sorry, 139, is it? No, okay.
Electronic 139 is the Cansford report.
Right, and this is in relation to grandmother.
Yes. It related, as you'll see on our page, hard copy page 139, to a sample of from a toenail. And at 141, internal page 4, there is no detection of any of those substances.
That's 12 months to the end of March.
Yes.
Approx.
Yes, the caveats in relation to the breadth of that period. Yes. And 146, which may be my lord's 147 electronically, there's the report in relation to the uncle. Here at 149, there is a sample of 21 centimetres taken.
So just pause a second. Right, so this was hair. Yes.
So 149, it's a lengthy hair strand sample. It's enough to tear 12 sections, and those are reported on page 150 with no detection. Cansford laboratories were also undertook testing in relation to the children. Child A's report is at page 6 of that bundle, which may be electronic 7. At page 11 of that bundle, internal page 6 of the report, there is detection. There is not detection of amphetamine, cocaine, ketamine, methamphetamine. There was detection in relation to cannabinoids.
Yes.
There are conclusions, page 12, internal page 7. Set out the conclusions. Possible ingestions occurred. Obviously, that's within a broad time period. It's not an absolute indicator of use. I would highlight the paragraph that starts the statistical ranges, because my learned friend on behalf of the Guardian draws attention to the high, very high, or high, medium to high.
Where are we reading
sample.
from?
The statistical ranges in the middle of the page. And what it notes is that those need to be treated with caution, as hair from children is more susceptible to incorporation.
Right, what, I'm sorry. Internal page?
Internal page 7, electronic probably 13.
Right, statistical ranges?
Yes, so this is the interpretation and
Yes, I
conclusion
see.
section. It's really the caution that whilst they've provided an indication in relation to child A, it's in the paragraph above in the medium to low range, they do say the majority of samples are from adults. Range has been provided, but they should be treated with caution. That only relates to Millen and Friends' treatment of those statistical ranges in the skeleton argument on behalf of the Guardian, where specific reliance is placed on.
Yes,
high
I'm sorry, I'm
medium.
obviously missing something. Where is the comment on the actual range in which the results fall?
Yes, apologies. So in the paragraph that starts for information, level of THC detected is in the medium to low range.
Right, so one then has to
Then there's the note of
one then
caution.
has to link it to the actual particular sections.
Yes, they aren't as straightforwardly presented, and the tests themselves.
I don't know how these are designed, but they're not very well designed.
No, but I would note that the note of caution, which is the relevant point, is that the ranges are provided for assistance, but need to be treated with caution because they relate to children, not adults. And,
Right, well, I'm probably at the back of the field, but I haven't yet understood what the picture is for these results in relation to A, in regard to cannabis, or where they are said to fall in terms of range description.
yes. So,
Help us.
in essence, the tables that are provided that start at the bottom of paragraph 12, at the bottom of page 12,
Yes,
that is the presence of CBN, one of the metabolites tested for within the hair sample. The most recent sample, 440167, is the most recent segment of hair.
Yeah.
And then that table continues. One can see again diminishing picture of results. And if one turns to page 13, the top two tables again set out. It doesn't present it with a date range, which isn't of assistance, but in a sense, but it continues across the following two tables.
Do we know or assume that these numbered samples correspond to the time periods we see at page 10?
Yes, because if one turns to page 19,
That's explained.
one can see
I see, yes.
in relation to each segment,
Yes, I see.
there is a page that relates to the findings
Yes.
that are made. But my submission on this is that again we have a picture of diminishing results across the entire period, much of which predated a move to the grandmother and uncle's care, to extremely low levels. And in relation to THC, another compound, these tables start at the bottom of page 13, again with the most recent samples, and there is no finding in the most recent samples.
right, and where is likely it's referred to ingestion as opposed to exposure?
The conclusion that they draw relates, so at the top of interpretation and conclusion, the presence of both the parent drug and the metabolite THCC confirms use or administration and excludes environmental contamination. The metabolite THCC is never detected in child A's care, so they say it's possible ingestions occurred, but it's not regarded as an absolute indicator of cannabis use. In page 13, in the text in the middle of the page, there's analysis of wash hair ratio is more likely this event is due to drug exposure rather than ingestion. But of course, exposure could be skin-to-skin contact, or it could be smoke.
And then in some, it's a combination.
Yes, and you'll see on page 14 the consideration of the different mechanisms for incorporation. And at bottom of page 14, the overall findings suggest children exposed to the use of cannabis within the investigated time period. And again, that is a broad time period. Over the page at 15, the analysis of the wash is said to indicate it's possible she's ingested a quantity likely in the form of second-hand smoke. So that's opposed to surface contact.
Right, and at the very bottom of that, no evidence of use.
Yes. And at page 15, internal page 10, there are again some important caveats. There is the observation that exposure has decreased in the time period. The note that ingestion doesn't infer intentional use. There's non-detection of the other metabolites. And then there are a number of cautions about hair growth rates, but also, and we included the article from Sarah Branson, which also includes, I think, a collaborator from FTS as it happens, that that there are distinctions in relation to hair type. So, my lord, in relation to child A, the picture in my submission is plainly not one of exposure to Class A drugs, which was the basis of the judge's conclusion. And in relation to cannabis, there are findings for periods that pertain to prior to the grandmother's care. There is a broad conclusion in relation to exposure in that period, but there are notes in relation to the decreasing time, the decreasing amounts that are found. And importantly, at the second to bottom paragraph on internal page 10, page 15 of the bundle, the last two lines, it's more difficult to determine accurately the period of drug exposure. It may have been within the month prior to the test or 6 to 7 months before sampling. And that is a common conclusion in each of the testing.
And to what extent, appreciating that we don't have the benefit of expert advice, but on the face of it, just doing the best that we can, to what extent do the negative findings in relation to Class A drugs conflict with the previous testing?
Yes. But there is certainly a period, I believe it's from approximately March 2023 to October 2023, where there is a straight overlap on the approximate time periods of the two sets of testing.
Yes, I understand they cover the same periods of testing, but to what extent are they apparently saying the same thing or apparently saying different things?
Well, in each of the up-to-date tests of the children, there is no detection at all of any metabolite for any drug apart from cannabis.
Right.
And so to that extent, it is very different to the findings in relation to Class A drugs that
But
have
as
been in
to
testing.
what the advice will be from an expert to the court about that, one doesn't know, because there are issues to do with timing, there are issues to do with sensitivity, there are issues to do with cut-off levels, and so forth. But I mean, just for a working judge, looking at this now, had Judge Jacklin been looking at this now, there would be an apparent difference
Yes.
of some importance between the two sets of tests.
Yes.
Is your submission.
And of course, insofar as there is testing from October to March, it is only the subsequent testing that covers that period. And all of those in relation to all of the Class A drugs that the judge was principally concerned with are not detected.
All right. So could you, in the time available, complete the tests for the other children?
Yeah, of course. Page 47 is the testing in relation to child B. At page 50, Lord will note that that is a toenail sample alone. There's no detection of any of the groups tested, including cannabis. And of course, that is, my Lord Justice Newey noted that it was in relation to child B that there is the narrow September to October 2023 finding in relation to cocaine alone. For child C, those tests are at page 50, the report is at page 56. There's a request for 14 sections. That's at page 57, internal page 2. At page 61 of that bundle, internal page 6, again, no detection of the of amphetamine, cocaine group, ketamine, methamphetamine, was detection in relation to cannabinoids. My Lords will see the raw results between pages 62 and 64. At page 62, there is a reference to this being the tests being in the high range, but there's the same note of caution about how far those apply to children. If one looks at the tables for CBN, cannabinol on 62 and 63, the most recent samples, again, plainly have a decreasing pattern that is noted.
Where is the reference to the high range, please?
Yes, apologies. In internal page 7 of that report, it's 62, electronic 63. In the middle of that page, for information, level of THC detected is in the high range when compared to other positive samples we tested. And then is immediately followed by a caveat in relation to that, principally relating to adults and needing caution in relation to children. My Lord, again, in relation to the raw results, one can see a decreasing result being produced for both CBN, that's on pages 62 and 63, and THC, that's 63 to 64. The opinion is provided at the top of 65, exposure within the investigated time period. This is internal page 10. Possible that there's been ingestion. As in the second paragraph on that page, additionally, it's my opinion the exposure has decreased. However, it can take several months for all drug residues to be eliminated from the hair once exposure to the drug ceases. And then at the bottom of that page, again, one has specific reference to the hair type. Second paragraph from the bottom, it's more difficult to determine accurately the period of drug exposure. It may have been within the month after test or 6 to 7 months before sampling. My Lord, in relation to child D, that result, the report is on page 97. At page 101, there's a 14 centimetre sample, 14 sections are produced. In the middle of page 103 is the detection in the earliest hair sections in the high range when compared to other positive samples. Most recent hair section tested in medium to high range with the same note of caution. And again, the conclusions at page 106 are likely now to be strikingly familiar to the court, in that the overall findings, top of 106, internal page 10, exposure to the use of cannabis within the investigated time period. Exposure has decreased in the approximate time period, and it can take several months for all drug residues to be eliminated. And then again, second paragraph, on bottom, it's difficult to determine accurately the period of drug exposure.
Yes.
So, my lord, overall, in my submission, the key question the judge had to ask was whether the test, as the local authority and guardian asserted, established a risk arising from continuing exposure, particularly to Class A drugs. That was the judge's specific focus. Do they suggest that risk? My respectful submission is, on a detailed analysis of the hair smell testing, in combination, as it has to be taken with the other evidence in the case, the judge's findings on risk were not sustainable as at the 26th of March. In relation to Class A drugs, that is put beyond doubt by the new evidence, in that those definitive conclusions were plainly called into question in a way that would need more careful evaluation. And that if one is focusing on cannabis results, one would need to consider the fact that there is decreasing exposure, there is several months to eliminate residue, the difficulties in determining the period of exposure, and the caution in relation to interpreting results in relation to children. The new testing evidence in relation to the grandmother and the uncle provide coherent evidence that even if there is some exposure, it may well not be them. Even if there is continuing exposure, which, with respect to Smith, it's hard to establish. And of course, testing doesn't establish who, what precisely, when precisely was happening. And it's notable that in presenting these up-to-date results within even the documents prepared for this appeal, the Guardian presents a table within skeleton argument called Bundle 337 with specific reliance on the ranges without noting the caution that is in the following paragraph. And the local authority appears to be engaged in reversing the burden when it says no primary carer has provided a narrative of how these results came to pass. It is for the local authority to prove its case that there remains a risk as a result of exposure, and respectively those tests do not provide a definitive finding, they do not provide conclusive proof of exposure, and the local authority and guardian do not appear to incorporate into their analysis the stark results in relation to both grandmother and the uncle that this court now has. So in my respectful submission, interim separation cannot be sustained on the case, either as at the 26th of March or on the new evidence, and the court will have my submission that the judge should not only have exercised caution in relation to conclusions on that testing, but adjourn for further testing to take place rapidly as was proposed. My primary position is that the matter should revert to the status quo without the matter being remitted for further consideration at this stage. That of course is in a position to say that the weight of the evidence, the impact on the children, means that interim separation is not justified.
In those circumstances, there are large parts of the judge's order that are not subject to the appeal.
No.
Indeed, it's something of a peculiarity that that it included both a removal and a testing provision. But from your point of view, until you've heard the submissions of the respondents, the remaining parts of the order, you would say, should simply remain.
Well, insofar as the testing has been undertaken, that's been completed. The case itself, more broadly, continues on with the broader investigation. I believe.
Yes, we'd like at some point to understand what Dr. Dowse is up to, and what his brief at the moment
I'll
is.
certainly try and investigate that to provide you over the lunch and adjournment if that persists.
Yes. Right. Apart from that, is that your
Unless I
case?
can assist on anything.
Yeah. All right. Thank you very much, Mr. Barnes. Mr. Miller, we'll hear you at 2 o'clock.
Thank you.
What is available?